So here is this Daniel Greenberg CB, right? Now, I've not actually seen a photograph of him before, but I've seen his name quite a few times, but he's only been put in place kind of more recently. It was a woman before him, but he's this House of Commons Commissioner, not to get confused with the Parliamentary and Health Service Ombudsman, who is also called the Parliamentary Commissioner, right? I actually got thrown off by that, but I corrected myself. Don't you think this guy looks like Klaus Schwab? He's very, very extreme. I mean, he could have been, look at that. You could have it could be Klaus Schwab who's in disguise, right? This could be Klaus Schwab who's in disguise as this guy. But apparently he gets voted on by the MPs. It's not appointed by the king, but apparently he's appointed by MPs. But this is the problem, right? Now, this goes back a long way, but it's been a gradual process. And my opinion is that the current modern MPs understand this, maybe not when they get elected, when they're members of political parties, but definitely when they're in Parliament. They should understand this, and they should know it. They shouldn't be too distracted with their, business meetings with people who want to invest in a local constituency and, ignoring constituents, or just going on photo shoots around schools to get publicity, or, radio stations voting on getting their agenda through Parliament. They should actually be aware of what is going on, what their predecessors have done, and what they're heading for or trying to head for. Because there shouldn't be any MP in Parliament who hasn't read the Bill of Rights or been interested in it, or have some kind of historical interest in the history of England, like David Cameron, Magna Carta. MPs surely can't be that stupid. Now, maybe some of the more modern MPs who are of various different ethnical backgrounds, who might not necessarily have a long history in England, might not be that interested in it. But maybe I'm wrong, maybe they might. So this video really could do with a diagram and a drawing. I mean, getting a pen and paper out and kind of just drawing it out on paper, at least with kind of lines and groups and things to show the progression and how it's been kind of sectioned off. But I'll do my best at just describing it verbally. I'm trying to make some order out of it. So we've got the Bill of Rights, right to petition. And we've always had that right before, from at least the observation of due process of law, right? Whether there's a parliament or not, from 1688, we've got the right to petition the king and or parliament, even if there isn't a parliament, and even if there aren't any MPs with privilege, right? That's our privilege. Now, when you look at the Bill of Rights, Article 9 with freedom of speech is not parliamentary privilege. The whole bill is privilege, but there are different things like we've got the privilege of not having to pay for elections, right? And then, there are aspects like the standing army part of it, but the right to bear arms, the right to petition, and it all fits together as it's a general model of how the different privileges apply and what they are in connection with Parliament and the country, right? And freedom of speech is just like one small fractional part of privilege, the whole big picture of privilege, right? Not just for MPs, Now, this is the thing. The current position we're at now, how Parliament have been trying to pass it off, is that we don't have any privilege. They truly have been trying their hardest to liquidate it, to literally get rid of it, to evaporate it. And then what that leaves is that we are protesting in public, and they're trying to frame it or sell it to us that, well, what the actions that we're going through in public, these activities are just, they're nothing. They're just, people in the streets making a song and dance or a lot of noise about something, and there is no legal supporting rights behind it, other than these ridiculous ECHR ones, like freedom of expression and freedom of speech, which are literally worth nothing. It's like, that they're judge decides whether you got it or not. It's not like you need to either have it or not have it to use it, right? That therefore normal citizens going about their own business, right? We're talking about legal processes. Everyone isn't engaged in a legal process all the time, right? They're getting on with normal citizens' private affairs, right? A private job or citizen going about their own business in a private capacity, right? Now, that is what the Public Order Acts are meant to enforce on citizens in a normal scenario, right? Whether or not it's going to a football match or going to a gig or going to work or going to the Olympics or just lots of people being out in the town centre, kids going out with their mates, gangs hanging around, all that type of thing is what the Public Order Act is meant to cover, but not legal processes. Now, this is the thing. The modern law is acknowledging legal privilege, right? Now, this is mainly solicitors and lawyers who are taking up legal cases and helping the defendant, right? Or the plaintiff. And they've got special legal protections to whatever the jurisdiction they're under. And all of these acts acknowledge that. Like even the Public Order Act, even the Terrorism Acts, 2006 and 2008, all acknowledge this. The the new Online Safety Act, right? It's all covered for legal privilege. Now, you won't find police officers arresting barristers and lawyers. You won't even find them arresting them when they're making representations for terror groups, right? Or even putting witness appeals out for terror groups. The police just won't arrest them, right? Now, the problem with the police is that they're thick, right? Because they don't know what they're looking at. When you've got members of the public who are making legal representations in public, but not as barristers or solicitors are going to court or a plaintiff or defendant, right? They're engaged in processes to Parliament, which are a lot more less restrictive and free, but mainly comprise of the activity of canvassing. That's the main activity, right? Although you can do investigation work, right? So it's equal and above police work, but the police just don't seem to want, I don't know whether they don't understand the law when they read it from the page, or they can't identify the people they're looking at or what they're doing, and they're totally being misled by the government or what, right? But it stems from the observation of Due Process of Law 1368, and then it's updated and supported with the Bill of Rights. You are engaging in a legal process, therefore it's legally privileged, right? But not to the Magistrates' Court, Crown Court, or High Court, to Parliament, right? And those type of proceedings require you to get a lot of people to support it, because the evidence that you're collecting is not fingerprints. The evidence you're collecting is not like blood on a jacket. The evidence you're collecting is not a written statement or two written statements. The evidence you are collecting is the public either signing, agreeing to, being made aware of so they know about it so they can do that, or writing into the MPs or Parliament, or filling in a petition, right? Or they could do it themselves. For matters and causes to Parliament, right? Now, this is all very clear in the 1688 Bill of Rights, but the MPs will close their eyes, put their fingers in their ears and sing la 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 whenever you want to try and mention the right to petition or illegal prosecutions in the Bill of Rights, but they will dance in daisy circles around this Article 9. Or it's like me, right? Not like us, right? Not like you. This is the thing. So, now, currently, the MPs have been doing absolutely everything that they could possibly try to think of to make out that we don't have these rights. Now, I think it goes back quite a while, but definitely probably from around World War II, right? Because actually, in fact, this woman, this Ethel Margaret Self, she petitioned the King and Parliament over a driving charge, right? Although it was more like an appealite type it should have been appeal-like jurisdiction to the House of Lords, but she petitioned the House of Commons. It did apparently get into the Journal, but obviously she, is the accused. She was not a plaintiff, or she was not a claimant from the outset to Parliament. She was a respondent to a case in the local petty sessions or local assizes, right? So therefore, she was petitioning by appeal-like, right? Appeal-like jurisdiction. Now, this is the thing. Probably about 14 days after she had a case in the newspapers, this is when World War II kicked off. Now, during that war, I think it was 1944, John Tinker, one of the decent MPs, actually in the special petitions report, said that, members of the public can present petitions at the Bar of Parliament, right, if it's over legal matters. But that was unfortunately 4 or 5 years. That was about 5 years after Ethel's case. Now, I think it was around 1948, 39, 40. Yeah, so after this Ethel Margaret Self incident, you start to get these things happening, like around 1948, they start to try and take away and diminish the privileges of the servants of the House of Lords and Knights of the Empire and things like that, and they start to track into the peerage privileges, but that's actually from around 1948 onwards. And then in 1967, with the Criminal Law Act, they diminish those peerage privileges more, and the servants' ones, but also and the lords, but also that is around the time when they create this Parliamentary and Health Service Ombudsman, or the Commissioner, so to call it. Now, before that time, before this mid-1960s, all the petitions would have gone to Parliament, right? But people, by this point, they've got a lot more departments in government and a lot more civil servants, right? And people are writing complaint letters. Not everyone does a petition to Parliament in that sense of petitioning, because a lot of people are just writing in complaints, or complaint to a Secretary of State, or complaints to MPs, or whatever, right? They're not usually doing it as a petition and collecting signatures. There was 1 or 2 instances. There was one, I think it was 1971-ish, something like that. I think it was 1971. It was just around the time of the Criminal Damage Act, when there was a teacher who did a petition, but she didn't actually do it to House of Commons. She did it to one of, sort of like, the head of education or whatever. It didn't get regarded or treated as a privileged petition. But let's go back a little bit from 1970s. So 69. If you look at the number of petitions that Parliament had been receiving through the 1800s, it was astronomical, right? But there's even more now, right? But the very high numbers, like they're in the tens, tens of thousands, and there might have been even more than that didn't get actually received. But they're all recorded down and noted in the 1800s. There's a lot from the army, and there's a lot from manufacturing, right? Because manufacturing wasn't just like big bosses like Jeff Bezos and Amazon and, Elon Musk or Bill Gates or, all these big, Dragon's Den type, Alan Sugar type characters who are lobbying Parliament for legislation. And they're the ones who are asking to get taxes changed. Because people were their own bosses more, or people worked more and had, a lot of unions, there was a lot of petitioning about taxes. Although Laura Corrigan did a, tampon tax petition, but there was a lot more engagement with the public in petitioning over taxes, manufacturing, and all that kind of thing, right? And what actually happened is that now we've got everyone started working for other people or underemployment of big companies, that they just went to work and got on with their own business, and they had everyone, voting for Labour or Conservative to sort out their issues rather than sorting them out themselves. And all the bosses are the ones who want to get new laws made and changed, because they can afford it, for one thing, and they own everything, right? And they negotiate and meet over the trading. Like, there was a big petition to the House of Lords arguing over, like massive tankers full of oil and who owns the oil and how much the oil's worth, and which big companies own which big companies what, and that. And the public taxpayers just went to work, and they mainly just grumbled about minimum wage and that, and apparently Labour was going to sort that out for them, right? So you don't have all these petitions about taxes and trade and merchants and card makers and silk merchants and candle makers and all these other type of people arguing over competition in trade from abroad and taxes and regulations on their area, and all that kind of sort of fell away. Now the problem is that Parliament's meant to be there as much for grievances as much as it is for amending and strengthening the laws, but Parliament managed to reduce the importance of petitioning by just pushing it to the side. No laws changed, and really the standing orders only changed a little bit, but they managed to sort of just push it out of the way so these major parties could get their business through, right? And also these private bills. But we still had the right, and people still did petitioning. But if you look, the numbers of petitions in the 19th century, in the 1900s, sorry, in the 18th century, in the 1900s, 1900, 1910, 1920, 1930s, 1940s, and 1950s is very, very low. Now, we don't know whether they were just rejecting petitions and not accepting them, or people were just doing it. I think, judging by the impression that I get around the time of Margaret Ethel Self, because that's just before the war, it's sort of between 1900 and 1940, so 1910, 20, 30, 40, there were some petitions, but not loads. And I think that, with the telephone and communication and with, postal service and, the radios and things like that, more ministers and people with a little bit more access to education, but and public transport, all these type of things, I think that people were usually dealing with complaints themselves, but usually dealing with complaints directly to who they're complaining against, whether it's schools and education, to the head of education, things like that, kind of as a letter and complaint. There were petitions to Parliament, obviously Ethel Margaret Self's petition, right? But this is the thing. But Parliament, really, if people knew what they were doing, Parliament should have probably been getting a lot of the complaints about departments by petition as well. I think that Margaret Ethel Self incident was probably notable, particularly when it went in the newspapers, and then the war kicked off and everyone was under war rules, ration tickets and all this type of thing, air raid shelters. She does mention that she wanted to set a precedent, petitioning the king. So it puts the question over, did that have something to do with the war starting? But obviously the war had been building up for a long time before that, and issues in Spain and other things. But, it's not anything out of the ordinary to say, hey, look, this is not a coincidence. This woman had this case in the newspaper about a major petition, and then, the war kicks off. They turn Ayton Light off on the top of, on the top of Big Ben, and then they chopped down all the bloody, windmills as well, didn't they, as well? That's quite significant. And then you got everyone with their heads between the knees with the air raid shelters ringing, right? So, now, this Parliamentary and Health Service Ombudsman, or as it was originally called, the Parliamentary Commissioner, that set up in 1967 after the war. Ironically, when you look at the number of petitions received and submitted, there aren't loads of petitions during World War II that we can see unless they all got thrown away or rejected. Now, that's strange because in the 1800s, when you've got all these soldiers and they're all in the British Empire and they're all going to Madras and Delhi and God knows where around the world in the British Empire, there are a massive number of petitions coming through from soldiers concerning the wars, right? And also to the retirement as well after. Now, we don't seem to see all these petitions similarly for World War II, which I'm not too sure why. Now, this is the thing. You would have thought people would have tried to petition not to go to war, but that's the difference between then and now. Just before World War II, there wasn't loads of different campaign groups about all manner of things that were kicking off about everything under the sun, right? Including the environment, Extinction Rebellion, Just Stop Oil, Defend Our Juries, you name it, people have got a campaign for it now, right? And they're furious with the government. Back then, they'd had World War I and there were some international issues, but apart from that, it seems like the 1920s and 1930s, people were, they'd been building all these, fairground rides and piers and things like that, Now, the difference between then and now is that now we've got absolutely everyone is politically charged and furious about one thing or another, and they're actually active in campaign groups and doing something about it, which wasn't the case, right, in just before World War I. So, now, this is a problem because, like, the police are arresting people. It's almost kind of like, the war is within borders between different groups that have ended up coming into the country, right? And yet the police are, meant to be the referee in between, but they're not really supposed to engage with political activities and they're arresting people illegally, right? Which means that they could potentially arrest whoever they want on both sides when they're not really supposed to get involved. And that's the alarming thing. So it's like the state kind of like stamping down some sort of authority over the people when we're not really at war and we're using political rights to settle disputes within the country, right? Now, this is the thing. People knew about the rights and privileges and powers. And the suffragettes actually were really onto it. And they'd actually been making quite a bit of progress as suffragettes. Now, in the early 1900s, there doesn't seem to be too many people bothering to use the petition process from what we can see in the actual petitions, although I haven't read them all because the records that we've currently got on ProQuest are like 1800s and they kind of stop in the 1900s. So those during the war period would be quite interesting to look at, although I don't think that those are digitised. Those ones aren't digitised, but there aren't that many of them. They're only like, maybe there might be 65 or 130 or something like that. But they will probably be easier to read if they've been typed. Well, I think they were still meant to be handwritten. Now, this is the thing. I'm not 100% sure how people were getting their grievances against the police or lawyers. Remember, they didn't have the Crown Prosecution Service. The police hired lawyers and barristers, right? I suppose the police could hire whatever barristers and lawyers they want. They could mix and match them, but they weren't necessarily an organisation. So if one lawyer or barrister did something wrong, the whole organisation didn't look bad or suffer. Whereas now, if one Crown Prosecutor does something extremely bad or wrong, then it makes the whole organisation look terrible, like same as the police and same as these big political parties, If Nigel Farage gets done for election cheating now, the whole Reform Party will crumble and fall, which is why he's vehemently denying that he cheated in the elections, right? So, now, when they create this Parliamentary and Health Service Ombudsman, right, which isn't actually supposed to have jurisdiction over MPs, but the rest of the government, I don't know why they called him a Parliamentary and Health Service Ombudsman. Why don't you just call him, the Ombudsman of England, the United Kingdom or the Ombudsman of Great Britain, because that's effectively what he is, right? Why call it the Parliamentary Health Service Ombudsman? They decided to call it the Parliamentary Health Service Ombudsman, right? Now, this is the thing. But he doesn't investigate MPs or in the House of Commons, or the Lords, which is insane and ridiculous, because why the fuck would you call it the Parliamentary Health Service Ombudsman if he can't prosecute or investigate MPs, right? But everything else, like government departments, like, the NHS or the Department of Transport or, Inland Revenue or whatever, right? Now, they decided to base the whole concept and ideology of this Parliamentary Health Service Ombudsman on petitioning, rather than just have it just absolutely nothing to do with the House of Commons. It doesn't need to have anything to do with the House of Commons. It could be a police of the police, right? You can have a police who police the police, or, in an investigations department who investigates all of, different various departments of government, right? But they wanted to call it parliamentary. Now, this is the thing. It's still a complaint, and it's still a grievance, right, about, one department or another. Now, the MP signs it off, right? He signs it off because they made him or her sign it off in the Act, in the 1967 Act or whenever it was, right? Now, that means that an elected MP who has judicial power in the House of Commons signs a document, a complaint, and endorses it. So it's effectively like a petition. Once an MP signs it and endorses it, right, it's received, and he's got judicial. It's officially a received complaint into Parliament, right? But the MPs don't themselves then have a committee, and they don't go and, go off and, investigate it, call for document, use committee powers to call for papers, documents and people and investigate it like a court does, but in Parliament, right? And they don't have an inquiry. So instead, this Act sets up a department, but it's not Parliament or the House of Commons. It's not a judicial authority or body itself, and it's not a court. But it can go to take a case to court, a little bit like prosecutors, really. And after the MP signs this off, it goes to the Ombudsman. Now, ironically, in the 1944 Petitions Committee report, as well as John Tinker, there's another guy, forgot his name now, it might start with a V, Mr. VN or Mr. CN or something like that. It's like a 3, 4, 5 letter name, shortish name, sounds something like Vien or Vier or something like that, right? But that other MP, he said that some of the petitions they've been receiving, they've been just like referring them directly to other departments, but without it being voted on in the chamber or a proper parliamentary committee dealing with it, right? And that was wrong. They weren't supposed to be doing that. They weren't meant to do that because those government departments, the complaint might have been about those government departments, and they don't have any judicial power or authority. So if you're complaining about Department of Transport, you don't want to send off a petition to the Department of Transport to make a decision on when it's complaining about them, because it's like, you don't send a fucking prosecution off to a criminal for him to decide whether he's guilty or not, right? It's like, oh, there's a man who robbed a car. Well, why don't you refer it to him then? Oh, yeah, excuse me, sir, would you like to, work on your own case against yourself? Well, that's why you don't send it off to, Inland Revenue or whatever, because it's the MPs and committees who are going to call for evidence to investigate the Inland Revenue, right? So it would be ludicrous to, send a petition to Parliament, to the Petitions Committee, and then just send it to Inland Revenue if it's a complaint about the Inland Revenue, because they're just going to put a hand up and say, oh, sorry, you were corrupt, So now this is where I think the thing with Parliament is whenever they're not supposed to do something, they like to fucking go do it, right? So if it says, like, do not push the big red button, right? They love going and pushing the big red button, right? Or if it says under no circumstances, put your hand up, they love to put their hand up, right? It's just how MPs are. They like to break the rules, but pretend, like, make up some fantastical excuse for it, right? So what they've done after this 1944 committee report, right, which is like, don't refer petitions to departments, they thought, we'll invent a department. We'll invent a department, and then we can sign them off to the department when the MP signs it. So we'll do exactly like in that 1944 committee report where they said they've been doing wrong, don't do that. We'll do it. And we'll even do it even worse. We'll actually make even more of a big deal out of it. We'll make a proper act for doing it, right? And then we don't have to deal with them, right? Now, the pros and cons of that are, on the plus side, on the benefit side for Parliament, they don't have to deal with, all the people's complaints about all these other departments of government, and they'll get a proper organisation to deal with it and sort it out. But the problem with that is, I think they're trying to make out that it's not privileged of Parliament when we investigate it, submit it, the MP signs it off, passes it to the Ombudsman, and the Ombudsman investigates it, right? Because they're even trying to make out now with this, this Klaus Schwab lookalike here, this Daniel Greenberg, right? They're trying to make out that if Greenberg doesn't take on your investigation, right, then it's not privileged, right? It's only privileged afterwards when he takes it on. Well, how the fuck did I get the evidence, right? How did I investigate it enough to find out there's something wrong and submit it? How did I send it in the post, free of charge in the post, right? This is the thing, when you post it in free of charge, right, that's privileged, right? So, and the Bill of Rights says that it's you see, this whole privileges thing, right, in the Bill of Rights is that it's like us and them, right? Now, how the Bill of Rights has it is that our role to play, our activities and proceedings are covered, right? And the MP's side are covered, right? And then it meets together. So the whole thing's covered like yin and yang, right? It's like yin and yang. That's like the Bill of Rights, yeah? Yin and yang, right? So we're covered, they're covered, right? Now, if we're not covered when we initiate and start it, then we can't do it. Now, the MPs in the Daniel Greenberg in the, well, actually earlier than that, because they were talking about it in this 1997 to 98 Parliamentary Privileges First Report, which I'm reading now, right? They're trying to make out that, if this Parliamentary Commissioner, House of Commons Commissioner of Standards doesn't take on your complaint, and he's never privileged. Well, how did you start it? It's still now. I'm kind of getting ahead of myself because I'm bringing in the House of Commons Commissioner into the equation, right? But I'm only bringing the House of Commons Commissioner into the equation now because there's an example of why they're trying to get the yin and yang. They're trying to get rid of our yin and say there's only their yang, right? We don't have any fucking right, but they're trying to make out, well, if he takes it on, then it's privilege of Parliament. So it's the real deal. It's part of the whole parliamentary privilege thing. It's just that this Klaus Schwab guy's doing it, and not MPs, right? Isn't he very privileged, right? So this is what I'd like to draw out in a diagram, because you can probably understand it easy if I draw it out in a diagram, right? But effectively, let's go back to the Parliamentary and Health Service Ombudsman, 1967. It seems like, even though the MP's signing it off and judicially endorsing it, then they're kicking it out the door. So it seems to me like if they're going on the basis that they're going with this House of Commons Commissioner, that the whole thing's been, ejected from, evaporated from privilege, and it's just some complaint that the MP signs off. So that's one way to boot us out, right? Like on the Monopoly board, kick up the arse, boot us out of the whole equation, right? That's one way to start getting rid of us, right? So, but it goes against what they said in the 1944 report, right? And there's another very, very important thing going on here. That 1705 resolution of Parliament said that it can't create any privileges which never existed, right? Now, you could say that, well, how is an MP who signs off a redress of grievance, which to the MP, thus so endorsed, right, by the House of Commons elected MP, why should there be an act of law that makes this Parliamentary Health Service Ombudsman Commissioner given the privilege to determine those complaints under an act of law and act against these, government departments, which, House of Commons are meant to be responsible for, right? So you could say, is that creating a new privilege? It's questionable whether the Parliamentary Health Service Ombudsman is or is not privilege of Parliament in the process, because by the way that they're talking about this House of Commons Commissioner, Daniel Greenberg, they're trying to even make out that that's not in privilege unless he accepts it and takes it on, right? So I don't know if they're trying to have the same principle for the Parliamentary and Health Service Ombudsman, but whatever powers they've got, they're given by the Act of Law, and they're given to them by the Act, not necessarily actually already existing under the privilege of Parliament, because they're not elected MP. But what it does is that the problem with the invention of the Parliamentary Health Service Ombudsman in 1967 is that we would be taking up the Bill of Rights to redress grievances about various government departments to Parliament and House of Commons, and that would be an official legal jurisdiction and process, and we would be privileged as much as the MPs, and they would appoint a committee and they would call for papers, documents and people to investigate it, and they might have a lot of complaints to deal with, but that's what it is. I mean, they used to have trials of petitions back in the day under the jurisdiction of the House of Commons, right? Like the trials of petitions, but it's not even that. That would be something if they just reintroduced the trials of petitions and had, committees, departments and people to do it. But they're not. They've tried to make out that it's not even that anymore. It's just like, it's a miracle that they even said that the MP has to sign it, to be honest, right? Which is a bit of a boomerang. But effectively, right, what they've done is they've created this person and given them all these powers in an act, and then they're going to sort of like complaints out for us, and it's all paid for by the taxpayer, right? Isn't that a good thing? Well, firstly, right, usually, let's get this straight. If you've been fucked over by the government or a department or the police or Inland Revenue or the CPS or someone, right, you're the witness, you've got the statement, and usually you've got the evidence that proves it, right? Or the evidence that proves it, and you just want to get court action, and you want it sorted out. You already know what's wrong, right? Instead, right, they've set up this department, you send your evidence in, but then they investigate it, but there's not really anything to investigate it because you already know what happened, you just want something to do something about it, right? And then they've got all these constraints and policy procedures and blah, 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 which are all hurdles to jump over to get anything going. And a lot of the time they don't act, or they don't even think that the government's department's done anything wrong, right? And notice it's all these people who have got, they've always got some kind of award from the king, like whether it's a knighthood, dame, CBE, OBE, or whatever, right? Servant of the crown. And they only allowed to have the position once, and they're getting paid a hell of a lot of money, right? But they don't seem to be able to sort out all these big problems. In fact, problems have been getting worse and worse, right? And it takes away our power to act and do something about it. And then you see, when you're doing it directly to the House of Commons, you want, if you've been wronged by any part of the government, right, you want people to fucking know about it, right? You want everyone to know about it, and and you want them to sign to make Parliament act. Now, the signatures are evidence that something should be done about it, right? And when everyone knows about it and you got all the signatures, there's a hell of a lot of pressure on government that they must do something. Now the problem is when you get rid of that, when you say we're not doing petitions to Parliament anymore for these departments, so you won't get loads of signatures, so you won't share it, right? Don't worry, because we've got a special department set up. Just send that complaint to the MP, they'll sign it off, and then the Ombudsman will sort about it. But no one really knows about it unless they, scrutinise and go through all the reports and that. And if they don't act on it, and if they don't deem that anything's wrong, then it's like, officially they're trying to make out there's nothing's wrong, right? Now, when you petition Parliament, you get the evidence down in the petition, you share it to everyone and tell everyone, fuck me, look at this is disgraceful. Everyone goes fucking mental, signs it, and then they kick the MPs up the backside and say, get this fucking sorted out now. And the MPs don't say, oh, there's nothing wrong, nothing's been done wrong, because then everyone will go fucking berserk, right? And, you could say, is the Hillsborough disaster, something like that, everyone got squashed and killed, was it organised by police, was it set up? This is the thing. Was the whole Hillsborough disaster, we'll show you who's in charge, like Cage Crush or whatever, that's a good question. But the Hillsborough disaster wasn't a petition caused to Parliament, it was just an incident which arose, right? Unfortunately, a very unfortunate incident, but there are a lot of questions around it. But those type of incidents are what aren't usually privileged. They're only, an incident which arises circumstantially, and there could possibly be a protest there and then, but it's not pursuing a legal action, which is. By a matter of record and writ, which people are making representations about and trying to get an action from Parliament. It's like a incident particular to, like a football stadium or with the police, and it comes under normal local crime and incidents, right? And that's actually where all the terrorism acts are meant to sort of kick in, and the public order acts, right? Maybe it wasn't the greatest idea to come up with that example then and throw it in there, but I did, because it's just an example of like large groups and things like that. When in that instance, a large group didn't make much difference. In fact, it was the largeness of the group and the response of a large group which caused injury to itself, to the large group itself. So it's kind of like a harbinger of, like, if you were a government authority which, was getting pressured into doing something lawfully, by lawful due process, by a demonstration, a very strong representation, and you usually would be forced to act. The Hillsborough disaster is an example of, like, big groups of people don't fucking, have don't tell us to do anything, like, fuck off, go crush yourself or whatever, go, I could crush a grape, or, or go fuck yourself sort of thing. I'm not saying that that's the case, but I'm just saying that if that incident was orchestrated by very cunningly, strategically placed people, and there was some kind of sheepdog whistle kind of, like, come by kind of, like, strategy behind it, to cause an international incident, catastrophic incident of misfortune like that, the incident itself has a message that, come and have a go, come and have a go if you think you're hard enough, big groups of masses of people, can't make anyone do anything, go fuck themselves or whatever, right? That's how I've started to, no matter how tragic the incident was, it's there's something in the gameplay of the government where, it could have been, advantageous to make that point, to make that point, no matter how upsetting or distressing it was to loads of people, but then again, kicking off with a world war. Anyway, so large groups of people with signatures are meant to be able to compel the government. Now, this is all before this 2000 Terrorism Act and so forth and so forth. When you read that 2000 Terrorist Act and the 2006 and 2008 ones, which have both got legal privilege, right? It's trying to frame it and paint a picture that the public don't have a right to force the government into doing anything because then they're terrorists, right? But we're talking about through strength in numbers, through request, through canvassing, through many people asking for it or demanding it, which this is democratic accountability. You're meant to elect your MP to do what the people in that area want them to do. And if they don't, they're not doing what they're meant to do, right? So you've got to compel them to do it, right? And from the subsequent 2000 acts, they're trying to make out that that's a sin or it's somehow evil or wrong or that's engaging in terrorism, and then they're going to prescribe you, when that's not the case. They cannot prescribe the legal process. Now, the police have got a very, very, very serious IQ critical failure with knowing what the fuck they're looking at, right, when people are engaging in a legal process, like barrister, solicitor, canvasser for Parliament, right? Causes and matters to Parliament. In the Bill of Rights, forget freedom of speech, right? Forget, proceedings in Parliament. Causes and matters to Parliament. Illegal prosecutions for causes and matters to Parliament, right? It doesn't matter whether you're at the top of Big Ben, in a basement cellar, in the House of Lords, in the House of Commons, taking a pee in the toilets, right? Either it's a matter and cause to Parliament or it isn't, right? Now, that doesn't matter whether Daniel Greenberg has got a sign on his door saying open, closed, out for 5 minutes, back in 10 minutes, go fuck yourself or whatever, right? When you send a complaint into Daniel Greenberg's office, either it is a matter and cause to Parliament or it isn't, right? Whether he takes it on or not, whether he scrunches it up into a ball and wipes his arse with it, right? Whether you're right or wrong. And that's what this Parliament can't get its head around. Illegal prosecutions for matters and causes to Parliament is our inherent constitutional right. And if you don't believe in that, you shouldn't be getting a job in Parliament, right? Now, a lot of these MPs, right, are so proud of themselves and their titles, they don't think we deserve that or should have it. Because we're all lying scumbags who make shit up and do frivolous, vexatious complaints, right? Maybe those complaints are true. Maybe they're serious. The word vexatious means of little importance. Now, the privilege of Parliament is never vexatious when you try to claim it because it takes priority over all other business in the House of Commons because there is no more important matter, right? Yeah, again, they're trying to play off the, you can't have a vexatious privileges claim. It can't exist. Right? And they're trying to water it down, dilute it down, and ahhing, even with themselves. It cannot ever be vexatious or, frivolous because it is the most important thing, right? And this is in parliamentary law. So no committees in Parliament can delegate it or dilute it or suddenly say, hey, it's not important anymore, right? Because it takes the highest importance of virtue of what it is. Because either it's a privilege claim or it isn't, right? If it is a privilege claim, it's important, right? And, you can read these acts. I mean, I've just, used a piece in a petition and straight out of these committee reports contradicting themselves. And it says, even the most small, it doesn't matter whether it's small or large, you've got the right to air the complaint, which is, some of these reports are so contradictory that you have to laugh at them. That their comedy value, they're almost kind of like, it's like the snakes and ladders. It's like snakes and ladders. 1 minute they're reeling out the historical importance, going up a ladder, and then they're like, then the next, and they're rubbishing it. In the next page, and then the next paragraph, they back up a ladder again. The whole thing is like snakes and ladders, these committee reports. It's like, the grand, great right to air even the smallest or largest of grievances. And then, so no, well, you haven't got any right, stick them up your ass because you're shit, right? And then, but down a snake, and then back up a ladder again, right? These committee reports are, if you understood them, right, what they're actually writing, these MPs in these committees, it's like the Riddler from Batman. It's like the Riddler. They're piddling all over it. They're actually taking the proverbial piss. It's like, it's like that, there was that famous Irish book that, when it starts where it finishes, the James Joyce book, whatever, I don't know if is it called, not Hercules, not Homer, Finnegan's Wake, isn't it? Yeah, Finnegan. It's like Finnegan's Wake, wordy wee, and then you start off where you finish again. They're literally joyriding. It's just stupid. But anyway, right, that's beside the point. So the Parliamentary and Health Service Ombudsman, so that basically helps MPs. They already did this move where they reduced, they tried to get petitioning reduced in Parliament so they could get on with their party political business that they wanted to get through. But in constitutional law, parliaments are called equally for as much to redress grievances as they are to amend and strengthen the laws. But we've ended up with a situation now where they only think they're there to do business, right? And MPs will this is what Led by Donkeys investigated, MPs will meet business people from all over the fucking planet Earth if they're going to invest in their area, but they won't even see any local people about local issues, and then they say they can't do anything about anything. And then if you're from another area, an MP won't talk to you, even if it's something to do with his area, unless you're a business person going to invest in it, and then they'll meet you, right? So they're just completely lying about even if you can meet an MP to take on casework, right? I've got an issue in your area, what about the MP, the Lib Dem MP for Richmond, right? Kew Gardens. I want to meet you about Kew Gardens. Oh, well, do you live in my area? No, well, I can't meet you then. But then a businessman rings you up and says, I want to invest in your area. And then they're straight into a meeting, giving them, 10 hours a day or whatever for business meetings. So they're just completely and utterly bullshitting us, right? And this is the problem with Keir Starmer, with his Tony Blair, business. They're basically, they utterly disregard the public, in my opinion, right? Yet, they're happy to pose for photographs. Oh, look, I'm at the school, we're playing tiddlywinks, or we're doing hand paintings, or here's a new investment in, making television programmes in schools. They pop up, they're like little pop-up moles. Oh, look, publicity opportunity. Oh, aren't I doing well? I'm a local MP. And then, oh, look, I'm at a radio station in the north of fucking Scotland doing a bit of PR for myself. This will get me elected again next time, right? So they're all up for photograph opportunities, right? What actually makes them look like they're fucking doing something, so that it helps them get elected next time because they put all the photos on there, right? But they're not actually helping anyone independently, individually, hardly, unless they're homeless or something. No one knows why these MPs are dealing with homeless people when homelessness is meant to be should be surely in the local council area, dealt with by the local council. Why is Parliament got to do with local housing issues, right? No one knows the answer to that. And then they're doing all these business meetings, with investors, right? Which is their main thing now. Getting or private bills or whatever people are banging through Parliament because they've got more money than sense, and they can pay to get these parliamentary agents to do it. Now that's another thing. The parliamentary agents used to get pay the clerks of Parliament. Now, really, in the 1800s, in the mid-1800s, Baron Denman made the Parliamentary Papers Act to cover for-profit companies and businesses that were engaging with Parliament when it had got material that people needed to know about or use, so it could be protected like privilege, right? But it wasn't privilege, it was like privilege for criminal or civil charges. Now, I don't think at that point they had parliamentary agents, right? I think they were still using the clerks of Parliament. You'll have to check. But if that's the case, when they did get parliamentary agents and have the organisation that deals with them, those parliamentary agents are working for profit, right? But they're dealing with matters of Parliament which should be privileged. So are they disqualified from privilege? Will they have to use the Parliamentary Papers Act? That's a good question, right? That's a question that I just thought of today. Because, with election petitions, that 1705 resolution would say you can't create any new privileges, but the election petitions were a complaint about MPs or about elections, which Parliament committees investigated and dealt with. And it was not supposed to be for profit, the process, and yet they ended up making, in 1868, giving the privilege to judges. Was that against the 1705 resolution? And then loads of private solicitors, lawyers and barristers started making private profit out of those elections, right? And then they ended up putting a deposit down to obstructors from even accessing them. That was another thing to take away, obstruct or remove our powers of Parliament, right? But they got a special law around it, like certificates of indemnity and all these other things, right? But in the 1688 Bill of Rights, it says elections ought to be free. But that the election petitions is another little example of how that, as well as creating the parliamentary ombudsman to deal with complaints about government departments like the NHS or Inland Revenue or the Department of Transport, etc., right? How they gradually are taking it out of Parliament. Now, for the MPs, it's great because they've got less volume of work to deal with, right? They've got less volume of work to do, and they're sort of like passing it off to other departments. But the whole point in petitioning Parliament, and why you don't already get it sorted out at a court, why do you appeal all the way up to the courts and then have appeal-like jurisdiction, when obviously you would go through the normal attempts to settle something directly. Obviously, if it's not getting sorted out, then you petition Parliament, and that's when you take up powers and use powers, and then when you've got privileges, and when you petition Parliament and get a committee to investigate, and they use those powers, right? That's the point. And this is the yin-yang, and this is a like, we've got powers, they've got powers thing. And then as they kind of like remove or operate on these processes, they're gradually trying to, if they get it out of Parliament and out of the House of Commons, then it's not privilege anymore for us, right? But they're creating these departments and giving new powers to the Ombudsman, to Daniel Greenberg, to the justices. So more power to them. So they're investing all the power in these figures who are going to do it all. But when we don't have the power anymore, right? But if we don't, right, we're the ones who've got all the information and knows what happened, right? but we send it in, and then if they make a decision that there's nothing being done wrong, then they don't act, right? Now the whole point of petitioning is like you've been wronged, right? The basis is like you, in your intellect, in your experience, in your wisdom, in your intuition, in your soul, spirit and being, you've been wronged and you want something done about it. You don't need to prove it. You don't need, this is why you get the signatures from the public, right? Because they agree with you and they support it, and they're compelling the government to act, like in the Inquiries Act when it says, if there's great public concern or if there's any evidence to substantiate an inquiry, there should be one, right? Well, you're getting the signatures from the public to make Parliament do it, not in a terrorist way, in a very strong electors. We vote, we've got the power, we voted you into Parliament and you'll do what we say, because that's democracy, right? Not like now, where when you do that, the police say you're a terrorist, right? Because you're forcing the government to do something. Just a minute, who are you? Who are you? The police think that Labour and the Tories somehow are king or something. Not that we vote for them and we tell them what to do, but the police won't even do what you want to do when you tell them, right? The police are meant to be elected and they're not meant to vote, right? And the police chief's meant to be elected, the sheriff, right? And the police now what do sweet FA, fuck all what you want them to do. They run around after dogs, people scratching and scraping each other, kicking, biting, barking, spitting, pissing, right? If someone ain't pissed on you, the police don't want to fucking know about it, right? They're like dog handlers now, right? And even worse, they're going after people who are like just fucking, typing shit on the fucking internet, right? They're not going after real criminals. They try and make out they are, but when they do, they can't find them, like, Madeleine McCann or whatever. Yes, there are murderers out there, but, the most, the most serious criminals are, this Larry Ellison guy, that Larry Ellison, he's the greatest criminal on planet Earth, right? But they can't get him for it because apparently, listen, unless you get a court order, Larry Ellison's making his own laws up. But for what country? There is no country. Larry Ellison's got his own set of laws for his own. Fuck knows where it's based, like on a satellite, on the moon. What country's this? Oh, it's called Larry Ellison fucking country. There's not the laws of England. These are the laws of America. These aren't the laws of Australia or Africa. These are Larry Ellison's laws. And somehow he's managed to get them, consent to accept my new subjects right over the whole planet. And everyone's obeying them. Even when it says in English law you're allowed to do something, right? I can't get someone to do it. Gonna go ask permission from Larry Ellison. Fucking ProQuest, can I copy these? Well, the English law says you can copy them, but I'll have to ask Larry because he's God. Hey, Larry, God! My king and country say this is lawful on this land, on this earth, but, Larry's policy of divine intervention, no one will do it. Because they've got the fear of Larry Ellison in them, it's consent to may accept. Larry says, it's like fucking Simon Says, Charles and Parliament say you can copy this petition. I'll have to ask ProQuest first. I'll have to ask Larry. Larry says 2 steps back. Larry says 2 steps forward. I'll have to get a court order. Larry Ellison's law, which is supersedes all countries now. And in fact, all the countries are signing up to it. This is the thing. So, our powers, they're completely and totally being expelled. So the next stage, they do get because the Parliamentary and Health Service Ombudsman wasn't able to deal with MP complaints, then they got this Greenberg guy, right? So this is the parliamentary, the House of Commons Commissioner, right? But that was 1995, sorry. Eventually in 95, they get this House of Commons Commissioner. Now he's dealing with all the complaints about MPs, right? Guess what? They're not letting us do any complaints about MPs by public e-petition, even though that's what it's for, what it's designed for, what it was made for in constitutional law for, and why it exists, right? So now, even though in standing orders completely facilitates for anything you want in an e-petition, more or less, right? That's what it's made for. That's what the standing orders and the law of England is for, observation, due process of law and the Bill of Rights. But due to a little policy by two MPs, the leader of the House in my whip, right, and the chair of the Commons, and a couple of little scribbles in a thing which mean diddly squat nothing, they are nothing in law, right? They're not standing orders of Parliament, and they're not the law of England. They are nothing, right? They are nothing. It's like, oh, Keir Starmer, he's the leader of the party. Well, I'm not going to vote his way. Well, you'll never stand for Labour again. Well, fuck off then, right? You know, this is the thing. Oh, you'll never petition Parliament again because we'll just reject it all, right? Not under this policy, you know? This is the thing. What they've done is they've created the Parliamentary and Health Service Ombudsman, so they're not expecting you to do any petitions which are a grievance about any department that's personally caused you or anyone else any trouble, right? Personal trouble, right? They don't want to know. They want you to write to your MP, get it signed off and send it to the Parliamentary and Health Service Ombudsman, right? And you ain't got no rights whatsoever. And they're not going to facilitate you a nice little online form to collect loads of signatures from the country and let everyone know about it. Oh, yeah, it happened to me as well, right? I'll sign that. This is the thing, right? We'll make the Ombudsman investigate it and not all these stupid jumping through hoops, right? You know, just fill the form, just fill 2 paragraphs in and get 10,000 signatures done, right? This is the thing. And then they've done the same with election petitions, got it off to the courts and put £5,000 obstruction in the way, and then they'll apparently bankrupt you if you, for costs if you try and take it on. And then they've got this Klaus Schwab idiot here, now Greenberg, right? He takes all the MP complaints. So they won't be expecting you to do any MP complaints through e-petitions. They won't be expecting you to collect 10,000 or 1 million signatures on it like with Tony Blair, to make someone act. And apparently they won't even take any petitions about honours, forfeiture, because apparently they can't do anything about it. Yet the MP, Rachel Maskell, got everyone to write into their MPs to do something about Prince Andrew. But that's what a petition does. An e-petition asks MPs to act, right? So why is it Maskell can get MPs to act, but she didn't want it on an e-petition when everyone signed to it, but they can all write it independently? So they're just full of absolute tosh, right? And they're making all these pigeonholes, and after pigeonholes now, they're saying they're not privileged, and then the pigeonhole which is left is, oh, well, this is just for amending and strengthening the laws. Policy requests, e-petitions. Well, private bills are policy requests if you can afford it, because you can actually tailor it like Savile Row to your own specific needs and get people to sponsor it, right? And, Labour and the Conservatives are already working on their manifestos and policies and getting it through, and MPs are voting on it, right? What's it left with for e-petitions? Well, if you want to get the tampon tax change, you can do that. Or if you've got a suggestion for a new law, if you're not, must grumble about, something we're getting put through Parliament, even though you've got a chance to, petition against and oppose the bills, there's meant to be a process for that, right? Oh, well, private bills and then, public ones is different. But they're rejecting them all. But it's not just that. They're actually lying and saying, I don't know what you're asking. But you're the one who presents a problem and they're the one who's got to come up with a solution for it, right? Or you're just asking them a question and you're criticising them something and you want an official response. You don't always have to go for the 100,000 signature target. There is a 10,000 signature target where you can get an official statement where you put you pose something to them, and they'll set in writing their official position, an explanation on it, right? Which is, you can get that for 10,000. But when you actually put anything worth saying down, criticising them on, if you put anything down worth saying or disagree with them, they don't want to run it, right? Because they don't want to have to answer to it officially. This is the thing. So, and the e-petitions is the only process now which is left, which they're actually saying that you've got privilege usage of, but then they come out with stuff like, oh, you can only share it online. Well, what happens if you're blind or if you can't write? You cannot print it out and pass it to someone, or you can't tell the person next to you verbally about it, which is just tosh. So, obviously you can share it, not just online, or else, what happens if someone hasn't got their phone on them, can't write it down on a bit of paper or something, right? So, it's ridiculous. Why would you need any, what would you need to use privileges for, just to ask for the tampon tax being changed? Even though, Laurie Corrigan was going around, advertising in public, right? So, but this is the thing when we get to these prescribed groups now, with all these old women and old men getting arrested, old people, right? Because they are canvassing causes to Parliament, matters and causes to Parliament, to try to get Parliament to do something about the groups they've just prescribed, right? But these old people aren't the prescribed group. They are not the prescribed group, and they are not engaging in terrorism, right? And the police are fucking delusionally thick, right? Absolutely thick as mince, right? Because those old people have got causes, a matter of record to Parliament to get action, and those people are raising awareness of it, canvassing it, letting people know about it, and getting them to support it and join it, whether it's to sign, look into it, or get their MPs to act, or write into Parliament, right? And they're getting arrested for that when that is legally privileged, right? That is not the terrorist group themselves who are acting unlawfully by using illegal methods to pressure the government into action, like, using a fucking rocket launcher or C4 explosive, or flying a fucking plane into 9/11, or taking down London Bridge, or whatever the fuck they're doing. And by the way, that's not putting Christmas lights on London Bridge. That is trying to dismantle the fucking thing, right? Or Roger Hallam making representations in public, right? Public nuisance is in public on public land, right? It's not on private property on private land. So, there is that. So what we've got the situation is that the government now are trying to pass it off as if what's left, right, after they stripped down, all the government departments to the Ombudsman, and then stripped down complaints about MPs to this Prince Daniel Greenberg guy, and then they've filtered e-petitions so they won't publish anything unless it's asking for tampon tax, or propose a law, or propose or oppose a law, right? Nothing else apparently exists when it does, right? But that's what you use the right for, and it's meant to be put to Parliament and signed off by an MP, and you meant to be able to share it, right? And they even say that in this 997 report, they write the importance of being able to air the grievance, no matter how great or small, and raise awareness of it. But that's why you do the e-petition, right? And this is why they're blocking them. But then they've got a team determined in saying whether or not it's valid or not. But how do they know if it's valid until when the committee investigates it? But it's not regarded as submitted officially until it's closed and you finish collecting the signatures, and then you submit it. They don't want you to be able to... Now, this is the yin and yang, because you got the right on our behalf to share and collect signatures and to present accusatory evidence. And what they want to do is what they've said about this, the House of Commons Ombudsman, who happens to be Greenberg now, right, is that they're trying to make out in this committee report that if he doesn't accept it and take it on, it's not privileged. So he decides if you got privilege or not, depending on whether your claim was valid or not, according to him, right? But the people decide whether it's fucking valid or not when they sign it, right? If there is public concern about a matter. The Greenberg does not give us the right. Now, the MP does not give us the right. The law gives you the right as a statutory power. A power under constitutional law gives you the right. And this is what judges don't like. Oh, I'll decide whether you've got a power or right or not. Who decides whether judges have got power or right? You know, they're sworn in an oath on an act of law. Who decides whether an MP's got power or not? If we don't vote for an MP, he has no power, right? We decide if an MP has got power or not, whether he's something or nothing, right? Now, them MPs do not judge whether we have a power or not, right? Our power is to collect, share, canvass, and submit the complaint. Done, right? And we are protected whether the MP likes it or not. Tough, right? Now, he can do what he wants with it. He can stick it where he wants, right? If it's valid, right, it's like court. If a police officer fucks you, right, you're fucked. Whether you win or lose, you are going to have to go to court, defend yourself, and prove yourself innocent, right? And it is a fucking hassle, right? It doesn't matter whether you're acquitted. And that's what the MPs don't get, right? If we complain about something, right, then we're going to complain about it. And if you can compel, we've got to make them investigate it. And if we're right, and if we share that information and people agree with it and support it, we have got to make them do it, right? And that is a demonstration of power. It's not terrorism, right? We tell them what to do. You can't be a terrorist in legal actions with MPs because you've got to make them do it, right? And if it's false and a lie, right, in a fair trial and hearing with a committee, but they don't want to acknowledge it received. They don't want it in their records. They don't want it on the list. What they're doing all the time is playing us back, right? It more gates and barriers because they don't actually, and this is exactly what they're doing with the professional standards in the police, right? You know, so the police do something, you know, whether they do it right or wrong, and then you complain to professional standards, and then, like, they're like, oh, well, you're not the victim, so you can't record it as a complaint. Well, what do you mean? Something was done wrong. I am fucking complaining to you about something which was done wrong, right? Oh, we're not going to record it as a complaint. Well, what are you going to record it as then? Well, it'll go down, but not as a complaint. No, I am complaining about something you did wrong. Now, this is the problem with the police, right? You know, don't call us, we'll call you. They militarize themselves, right, to protect, you know, from, you know, crank callers or whatever the fuck it is, right? And they've reinforced and, you know, they've been working on themselves so much, like, like the fucking, you know, like fucking Batcave, right? Like a fucking Batmobile, you know, with a fucking shield and armor on, that they're making themselves invincible, right? Invincible to even complaints about them. So you just can't win, you can't beat them, right? Even when and then they even got ex-police officers working in the police complaints department commission and so forth, right? So they're reinforcing themselves. You know, you can't have their phone numbers, you can't ring them up. You know, this is the thing. So, and what you end up with is, you know, actually they've completely and totally, you know, okay, there are complaints that, you know, get action on. There are complaints get in the news, right? But they're never any of the serious ones. And this is what I said in the other video I did about, vexatious and, frivolous complaints. It's always the frivolous ones that get in the news and always the frivolous ones that gets acted on, unless it's something like, fucking girl goes missing with a dog or something that causes public outrage because it's good for police. And, oh, yeah, a little girl got lost in the forest, so we need police. You can't live without us, right? It's always like Madeleine McCann ones, stuff like that. But not like, all of the police are corrupt, like the police officers have been doing this wrong, all the police officers have been doing that wrong. Anything which can cause critical fucking damage to the police force itself, and too right it should, because utterly corrupt, and insidiously, perverted some of them, right? Anything which actually can have a substantial effect on the whole force is completely and utterly blocked, right? Only frivolous things, get acted on, and this is a problem now. Also, but you can't have a frivolous complaint to Parliament. Nothing to Parliament is frivolous, You might as well say tampon tax is frivolous, Why get tampon tax changed? That's a frivolous thing to ask for. It's a bit of tax on tampons, Well, it's, taxes going up on cigarettes, going down on, booze, up and down. It's like snakes and ladders, swings and roundabouts, right? So why does it matter? If there was anything frivolous, surely it's tampon tax, right? But oh no, Theresa May has got a high priority, This is the thing. So it's just, what the truth of the matter is that there are very, very serious complaints to Parliament by petition, which are getting utterly and totally censored, obstructed. So you can't compel the government to act, right? And they don't want it down on the record. So this is the thing. And they think it's only there for, nice little... They want it to be like a friendly little, they want it to be like kids' parliament, when they invite kids into parliament, to have like a junior parliament and, everyone's happy and smiling. And the MPs want parliament to go smoothly, like a photo shoot at a local fucking Ayrshire radio station. Oh, look, it's Jamie Stone. I'm off to visit a radio station, giving myself a bit of PR, right? Oh, look, aren't I doing well? You vote for me next time, right? Oh, I'm at a school, we're doing some finger painting, he's doing a really good job. That's what MPs would like their job to be, but that is not the job, right? Because Parliament is there to settle grievances. And if you don't settle them, then the complaint's going to be about you for not settling them, right? So, and what, I think what the Labour and the Tories have transform Parliament into is their own little business project when they can, block everyone else out, don't have to deal with all the complaints, and you just, it's happy, smiley, sunny day in the park or whatever, right? And let's get business through, right? The party business, right? When it's not even meant to be there for party business, it's meant to be there for, it's meant to be there for the local people in the local areas, right? And the MPs voting on it. And really, all the MPs should have different opinions. It should be very difficult to get an act of law through Parliament because you've got to get all of them to agree. All this stupidness of like, Keir Starmer, you'll never stand for the party again if you don't vote my way. All this like, we're Labour, this is our mission, this is what we're going to do, we're going to get these laws through. That's actually, what's the point, what's the point in any MPs turning up? All this control of council or whatever. It's pointless. What's the point in debating? If all of the Labour MPs are subscribed to the same manifesto and policy and they're told what to vote on or they're out, what's the point in them voting? And in fact, they only now pair up certain MPs with, depending on how many votes they're going to get in opposition to it. They don't even bother getting them to turn up or going in, right? Which is like Nigel Farage, who never turns up, on Matt Hancock in the jungle. So there is actually, the debates are pointless now, because if you've got a Labour majority and it's going to get things voted through, there's no point debating it, because the MPs are already agreed on it, right, in their own party. So they're only debating with, what's the point arguing with a minority who aren't going to win, right? If you've got a Labour Party government who've got a majority, right, and the other MPs, it doesn't matter how much you debate and if you've got a better point or not, because if they don't vote Keir Starmer's way, they're going to get booted out of the party. So even if you've got better arguments than them, you're not going to persuade them. So what's the point in having a fucking debate? There's absolutely no point at all. And this is why Starmer wants to get more Labour peers into the House of Lords, right? To break up these oligarchies, when there shouldn't be. This is even Steve Barrett, the barrister now, is saying, we should get rid of political parties. They should be banned. We shouldn't allow them. People should vote on an MP because of their personal characteristics, honesty, trustworthiness, intelligence, intuition, abilities, and have actually some working knowledge of Parliament, right? That's why you should vote for an MP. And then all of the MPs should actually have very heated and engaging debates and have to come up with very compelling evidence. And that's why the standard of evidence is so low. And I'm not talking about when they go, oh yeah, we did a public consultation and we got loads of professors to write in and we've been looking at the latest science reports and updates and this and that. I'm talking about when you're in a committee meeting, when it's been televised, when you've got MPs, some plump female MPs. I'm not being, that's not discriminative, but that's actual based on fact, right? Coming out with just the most, actually a 12-year-old school child could have replaced her and gone and said that, right? Like the woman in the Michael Westwood debate when she's like, we've had a lot of foreign interference in this petition, blah, blah, blah. Well, just, where do you get your policies from? Sadiq Khan's, international committee or something. This is the thing, but just the most, things that you've already heard said on YouTube videos over and over about 20 times, and then they'll just say that in the meeting, and they're like, why are you saying that for? We already know that, super basic. But yet they're making out, we're doing a consultation and it's going to be very technical and complicated, and fucking nuclear physics degree, or let's get Merlin Sheldrake in and talk about the biodegradation of fungi in the woodland or something. They break down the biodiversity fucking processes, whatever, but you don't hear that in these meetings. Actually, what you hear is completely and totally superficial, childish, simpleton comments, which are neither intelligent nor informative. They're a shadow of what you used to get in the 1800s in committee reports and meetings. It was much more intelligent and informative. So, it's just pointless, completely and totally pointless. And the fact that they're blocking us out of writing any substantial amounts of information in the e-petitions online, even though you can put links in there, but whenever you put a link, they always reject it anyway, and say that it's from some invalid source or whatever. But who's to judge that? They're not judging that in the committee meeting. This is it's not even accepted. It's not even regarded as being officially submitted until it actually finish running its course, right? So, and they're not actually supposed to be looking at it. The Senate standing orders are that a petition is never received until it has 150 signatures or two. So, I mean, the petitions, and they don't even consider them as received and submitted until it finishes running its course. So they're not actually meant to be able to look at them until it's got so many signatures on the Senate, but they do so For example, they're running the Synod wrong. There's an argument for that 1705 resolution that the Synod's illegal anyway because it creates new privileges. That's another thing. The devolution of Parliament, the whole ideology behind it, like they're going to devolve Parliament and break it up, is actually illegal. Because what they're actually doing is they're actually delegating privileges to other areas and then giving them away to other parts of the government, not the House of Commons. And that is actually, all that is against the 1705 resolution. And the thing is, if they try to say that, that resolution doesn't carry on, all of the Petitions Committee resolutions, which actually in the 1832 committee report, it says that they don't necessarily carry over, they've been vehemently pushing that they are carried over. Like, they can reject it, they can reject petitions if they're not fit to be received and things like that, when it actually meant mainly for spelling mistakes or for whether or not the writing was clearly written or not, right? And they're pushing that all those resolutions were carried over and are still in effect, right? When the 1832 Petition Committee report suggests that they might not. But then when they're wanting this, like, the 1705 resolution doesn't carry over. But if that doesn't carry over, then what does? This is the thing. They, when they want it to carry over when they want it to, and they don't want it to carry over when they don't want it to, right? So it's just all tosh. So what we're left with is they really, really want, let's go back to the actual petitioning now, that causes and matters to Parliament, as it's called in the 1688 Bill of Rights. They want everyone to believe that what is happening in public is protesting. It's not privileged. It's not a parliamentary process. It's just people in the streets complaining, right? Vaguely about, democratic matters. And the police can regard those people as terrorists, right? Not recognise it as a legal process. And when the police prescribe terrorist groups, apparently includes people who otherwise would be making legal representations and be protected, but apparently they're not anymore. And this means that, the police can just go around arresting anyone, and there aren't actually any processes of law left to Parliament, right? Or you have to pay barristers to do it in the courts, like with election petitions, and no one can afford it, which is the problem why we don't hardly have any election petitions, right? And this is why everyone's getting confused about the Public Order Acts, because they're only meant to apply to things like Hillsborough, football matches, O2 Stadium, Olympics, gangs and youths and mobs in towns and villages, people at work who just refuse to work and start kicking off outside the industrial estate or something like that, right? And therefore, it leaves us without any powers, and this is why the police are going around and arresting everyone. Now, what happens is, we're not at war at the moment officially, right? But everyone's got all these political causes. Now, if all these political causes start fighting each other, the police are going to try and reckon that they can step in when really they can't, right? It's just, that's the case when you've got a boxing match. If two people want to fight in a boxing match, then it's up to them, right? And the police don't like that. They can't accept it. And this prescribed group nonsense, when people are going around with signs and banners, right, they're acting lawfully. And that Terrorism Act actually says things that aren't lawful. But the police can't get their head around that the whole point in petitioning is to have the strongest demonstration possible. You're meant to force government to act, right? Politically. Now, they've done some writing in the Act, which the police are interpreting like to do that is illegal, apparently for a prescribed group. But that's you can't do that because then you can't have the legal action, right? And they're getting the two things confused. That, they're trying to make out because it's a certain subject, a certain matter, and it's prescribed that you can't have any legal actions for it. And you can't force the government to act in that thing when you can. When you're using signs and words, right? Not when you're using rocket launchers or fucking 9/11 incidents or whatever, right? And that's the thing. Otherwise, you couldn't have lawyers representing them or doing witness appeals, which you already said. So, I mean, that's pretty much it. So, they've been desperately trying this. It's part of this devolution, and I think they're all in on it. And I think they'll try and make out that, oh, no, we didn't know what was happening because it's been happening over a long period of time, right? But I think they do know what's happening, and they're all heading towards this certain plan. And it actually is, it's part of this whole devolution process. They don't want us, the public, to have any powers. And what's going to happen is, there's no point having a court who will make a judgment if you've got to go through the ombudsman who's got to look at it and then make a judgment, because the ombudsman is actually really doing what the judge is meant to do, right? But they're meant to kind of like be your lawyer and represent you, so it's like they're making this, oh no, we don't think they did anything wrong, or we're not going to act. Well, the whole point in the petition is that you're going to make them act, and that a large number of people do believe it's true, and we're going to make you try to prove it. But it's like, so with the ombudsman, really, we're supposed to be really able to let people know about the complaint, collect large numbers of signatures, and force the ombudsman to try to prove it in court, right? Even if they don't agree with you, because that's what the court's for, to present evidence and try to prove something. If the ombudsman agreed with you and they thought that you were right, then, you already won, really, haven't you? Because, what's the point in going to court to prove it? They might as well just give you the fucking money out there and then. And this is kind of what Starmer's wanting to do with his stupid automated fucking dole process, where they just look at you and think, oh yeah, you've not paid this and you're guilty and we take the money off you, right? They're rolling back all the time. They're rolling powers away from us, right, into these Daniel Greenberg guys and into these ombudsman figures and into the courts at the election petition. And then they're rolling back the powers from the courts to these bodies. And these are the organisations like that we're paying for, right? We're funding them. And all they're doing is collecting all the information and fucking assessing it, and like the Advertising Standards Authority. But we're paying for them all. And then the police are getting more and more and more powers, and we've got less and less and less, so they can arrest us for anything. And we're getting to the point where the police are arresting us for having a political opinion. The police are arresting us for trying to get the government to act, when we're the ones who are meant to vote for them and tell them what to do, right? So you're going to end up with, we're not going to have access to courts. We're going to have these big authorities who have got all the powers instead of us, and then they decide they're like ultimate supreme judges themselves, automatically deciding things remotely, a little bit like what Starmer's wanting to do with his fucking dole thing, and then the police just going around and literally, it literally is like they're going for this judge. It's like the Judge Dredd comic, You must have seen the Judge Dredd comic, the Judge Dredd thing, when you've effectively got these police officers going around doing justices. But I mean, it's not even going to be like that, because they're giving it to these remote bodies who are just going to do it remotely. So it's like you wouldn't even need the Judge Dredd walking around the streets. You're just doing it remotely, So I mean, it's all automated. And I don't think it's any way to live that, because it's completely getting rid of the jury, and public convening to discuss and sort out matters as a community. The whole basis of juries is kind of meant to be communities convene, but under kind of not like online Facebook groups where a couple of inexperienced maverick admins who don't know the law are just fucking deleting and removing people and making judgments without any proper lawful due process. And even some of the group might actually support you and back you up, but then once you're removed, you can't get their support. You don't even have the right to talk to other people. And that's how Mark Zuckerberg and Google have YouTube have been playing it so far, and the government seem to like that because you don't really have access to the rest of the community deciding on whether what you did was right or not. With law applied, you just get a couple of maverick moderators and admins, and you don't even really know them properly. And a lot of times they don't want to fucking talk to you anyway. And a lot of them even don't have the same opinions. It's very, very, very... And then you get to the point where, you've got these big corporate entities who are running the whole thing, and they're like, oh, we've got a policy clause like any reason or no reason. How is that got responsibility? Can you imagine if they're running the courts like that? And that's actually what happens when you get rid of the juries. They're going for, we know what they're going for because these are the policies they're coming out with, like, any reason or no reason. And that's effectively what I think it's going to come down to when they're using all these remote powers with the the dole claims and that and stuff, and this is how people like this Larry Ellison like the world to run under his supreme empressy, any reason or no reason, whatever, unless good court order, we'd be surprised if there are any courts left, right, So that's where we are with it. And it's clear to see what they've been trying to make it out that it's all for convenience. So it's convenient. Look, right, there's never been as many members of the House of Lords in the history of England, right? But yeah, we've got all these departments who deal with stuff like they don't have to deal with election petitions. We don't have appeal jurisdiction in the Lords. So they've actually got less things to deal with from us, and all they're doing is getting their own business through. But yeah, they've never had as many Lords. And I don't know why they're doing that, because they're literally like spare pricks in a brothel. And then it's not the best comment to come out with because it's like a cheap comment, but it's true. What are they doing with all these spare end Lords? Have they got a spare Lord to change a light bulb? With all these Lords as members, all of these services should be in Parliament under proper constitutional law, and we should have powers and engage and, be able to compel them to get action and not have all these multiple departments, getting all this funding, and it's all being paid for by these black holes that actually don't even fucking exist, pretend money which isn't there. Yeah, they've got more and more Lords. So, I mean, something needs to happen because we can't carry on like this. We can't continue like this. Our powers are being devalued as much as our money and the cost of living is being devalued. And the whole in government is like infinite. And yet all these other entities have been actually making all the plus and all the profits out of it all. And now they're wanting to, have this oracle thing, fucking dictating law, predicting everything. I mean, this Larry Fink guy really is he's a loose. I just can't believe how he's got the balls for it or the nerve, to be honest. You cannot be aware of humanity if in a position like that. You can't, you've got to have a sandwich short of a picnic because no one could keep and hold their nerve. Oh, you might say, well, he's got a, mind of steel like Superman. Yeah, a mind of stealing, like Lex Luthor, the greatest criminal mind of our time, and he wants to make himself a supercomputer,